fine. Just a quick announcement. Just an announcement to our colleagues here. Good morning. We were scheduled to start at 9:30, and we were forced to postpone because our first witness, Mr. Naidu, indicated that they are stuck in traffic. It's raining in Cape Town, and at the time he indicated that they will be about 20 minutes late. So as soon as they arrive, we will start. We just thought that we would make that announcement so that you don't wonder why we are delaying. So it is because Mr. Singh is, I beg your pardon, Mr. Naidu should be with us shortly, and we will start. Thank you very much.
It's terrible in Cape Town today. Actually, N2 is flooding. I've never seen anything like this. It's just lucky that there were no accidents, but I can tell you a lot of people are going to miss their flights, and we will have quite a few accidents. I think the system has blocked. No, it's the system that has blocked. Your stormwater drainage has blocked. In the best-run, so-called best-run municipality, the DA has failed the people.
Honorable members, maybe we should start because we had some housekeeping work to do, and there is no reason why we can't deal with the housekeeping work, and Mr. Naidu will then at least have 5 minutes breathing space to catch his breath before we start. Is that okay with members? Thank you. The normal housekeeping rules, could we put our cell phones off? Mr. Waters, as you know, indicated yesterday that he is on other parliamentary work. Honorable Swartz indicated yesterday already that he will join us at 10 o'clock, and there should be no other apologies. Honorable members, just very briefly, our program for today is the first witness would be Mr. Krish Naidoo, who is a former board member. Followed by Mr. Molefe, who is a former acting CEO of the SABC. And after lunch, Mr. Tsitsi, who is a former group executive, risk and governance. That's the program for today. And we will get underway accordingly when Mr. Naidu arrives. You will be aware, honorable members, that yesterday committee requested an opportunity to go and consider overnight how we process the requests by witnesses who want to testify in camera. The second issue that we were going to finalize today was a request made that we consider adding multi-choice as a witness because of the archiving interest. So we want to report on those two, get your your comment and dispense of those matters. Let's start with the easy one. On the request that we add multi-choice or their representatives to the witness list, having thought about it last night, honorable members, I want to propose as follows: that as we speak, there is a process that is currently underway to retrieve the information from the board of the SABC. And therefore, I want to suggest to committee that we allow that process to reach its conclusion and exhaust that avenue. Because I believe to do anything differently would be premature. And also indicate that if all else fails in terms of trying to secure that information from the SABC board, we then can consider the option of adding multi-choice to come and give us that information. So my proposal is that we don't enter another witness at this point until the process has been concluded. So I thought I'd put that one, and you need to respond to that one. The second one is a bit more complex, honorable members. The issue around, do we accede to the request to have any session in camera? Again, overnight, I thought about this matter, and I thought, honorable members, to contextualize my resolution at the end, I should start by the supreme law of the land, the Constitution. And in the preamble of our Constitution, it indicates that in adopting the Constitution, we therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the land, as I said, so as to, and this is the important point, so as to lay the foundation for a democratic and open society in which government is based on the will of the people, and every citizen is equally protected by the law. I premise my recommendation to committee on that. But also, honorable members, Rule 119 of the National Assembly directs that all committee activity, we must ensure public involvement in accordance with the provisions of the Constitution. That's Rule 119. And there is another rule, I think it's 184, I'm not sure of what rule it is, that outlines the process in the event we want to take a decision to have a closed session. And that would involve the leadership of Parliament and so on. So having considered all those things, I want to propose as follows, honorable members, that we should be sensitive to the concerns that have been raised by the two witnesses that we spoke about yesterday, and not dismiss their concerns. But at the same time, honorable members, we must also ensure that we maximize transparency in the work of Parliament. I also think, honorable members, that we should never compromise on being consistent and operating in a manner that is fair to everybody. The final point that I want to make, honorable members, is that in considering the proposal that I want to put on the table, I think it's incumbent upon this committee and also on Parliament to communicate to all South Africans that on accepting employment in the public sector, we must understand that that employment comes with having to be held accountable. Whether you're currently in the public service or whether you've left the public service, but anything that happened under your watch, you should understand that you will and must be held accountable. And therefore, honorable members, and I'm raising this of accountability because we toyed with the idea of whether if somebody is no longer in the employ of the SABC, we should not be more lenient. I'm arguing that as long as it happened under your watch in the public service, you must understand that you'll be held accountable. The final point that I want to make, honorable members, is that we've started a process yesterday or the day before, and have gone through at least 5 witnesses who themselves came here not because they wanted to come here, but had to endure whatever pressure or pain they had to endure. To change midstream would seem to me to be unfair to those that had to go through the process. Having considered all those facts, honorable members, I want to propose that our position is that no session will be held in camera. It must be very onerous on anybody to come to Parliament to want to argue that he or her session must be in camera, for the reasons that I've laid out now. So firstly, that we put multi-choice as a witness on hold, and secondly, while sensitive to all the concerns raised by honorable members, by potential witnesses, that our principal position as the voice of South Africans is that there should be maximum dissemination of information that is in the interest of South Africans, and therefore we must deny the request to have any session held in camera. I will then open it up for members to comment on these firm resolutions that I'm putting, or recommendations that I'm putting on the table, and then let's take it from there. Anybody wants to comment? All right, everybody seems to want to comment. All right, let's for change start here, Mr. Chauke. We'll go up the line, down, and we'll end up with the Honorable Mahlangu. And also, honorable members, because we really do not have a debate on this thing, every member will be given a minute to make his point and we'll take a decision. But let's start with Honorable Chauke.
No, thank you very much, Chairperson. I will firstly comment on the multi-choice proposal. In fact, I made that proposal earlier. And I will want to agree with you, Chair, that if there are other processes that are currently underway, and therefore I will definitely abide by the decision that you have taken. It's a correct decision. We'll then have to wait and watch the space so that we get to the details of that, and I'm okay with that, Chair. On the other issue of a closed meeting, obvious, in the best interest, again, of the public and the transparency process that we have been engaging in as Parliament, I will again want to really support the decision that your conclusion that you came up with, which really put us in a position that the public always will be on board in the process. And thank you very much for that.
Thank you, Chairperson. I support your recommendation on the multi-choice. We can always call them in later. As far as the second point on, as you introduced it, regarding closed in-camera sessions, I concur with you that we have a duty. as a parliamentary committee, in terms of our rules and in terms of the Constitution, we have a representative democracy based on openness and transparency. And I think we should heed that. Also, our rules, 184, gives effect to that, specifically to allow for public scrutiny of what we do. And we can always, when we get to matters, ask people some of the information they can provide throughout to you, so that it could also inform our business and conclusion of this matter. Thank you, Chair.
Honorable Olive.
Thanks, Chair. Chair, I agree with both proposals, but I want to land by rehashing the fact that those who come and testify here are not supposed to be threatened by anyone, because they are doing this so as to let South Africans know what is happening in their institutions. Thank you.
Honorable Khoza.
Chair, I'm covered. I support both recommendations. Thank you.
Honorable Phumzile.
Thanks, Chair. I support both proposals. On the first one, the SABC first and foremost accounts to Parliament, so they must provide the documents to us. And then on the second one, like we've discussed before, ensure that there's protection for those witnesses that are threatened or are receiving death threats. Thanks, Chair.
Honorable Mafanga.
Chair, thank you. I support your proposal and what colleagues have said. But I think as a rider to the close issue, you already had some close meetings with several people, including the lawyers of Mr. Maguve, Professor Maguve, and other people, which you briefed us about. And if there are compelling matters that they would like to raise with you, perhaps ahead of the meeting, if indeed there are such things that you could then bring to our attention, would appreciate it. But I think in principle, we stick to the process that you have outlined, which is fair. And indeed, I would agree with the colleagues who are saying, in case we have people who have been already threatened, I guess those matters should be put on record here in the meeting, and such people should also lay charge with the police. And I think we should also then be supporting them in those initiatives. Thank you.
Honorable Mokoena.
Thanks, Chair. On the multi-choice issue, I think, no, I agree with you 100%. But can we just get an update maybe at the end of the session today as to the progress in terms of getting those documents from the SABC? And then on the second issue, I also agree. We did put Mrs. Mokhobo under scrutiny here, and she was threatened. So there's no one else that we should give freedom. So I've changed my mind on that. I do think that we should send a very strong message to whoever at the SABC or anywhere else that is threatening people who come to this platform, that we must lay charges and we must protect these witnesses that come here. There is no one that is supposed to be threatening anyone. We must send a very strong message to whoever at the SABC threatened Mrs. Mokhobo or whoever else is going to come going forward. Thanks, Chair.
I thank you, members. So that is the decision of the committee, that matters of multi-choice will be put on hold until all other options have been exhausted, but we reserve the right to call them if indeed we want to call them. And secondly, that all our sessions going forward will be sessions open to South Africans who have an interest in what is happening here. We're not going to revisit these matters again, honorable members, because this decision is a decision taken by a duly correct committee. So I'm hoping that those things are put behind us. And I also note that Mr. Naidu has joined us. Sir, we did get your apology that there were traffic problems, and that was accepted by members, but it also afforded us an opportunity to do a bit of in-house matters. So we'll start with you in a second, and I'm assuming that by now you You have caught your breath, sir. Thank you. Mr. Naidu, please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry. Notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceeding or damages, you are, however, protected in that evidence given under oath or affirmation before a house or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. I have been informed, Mr. Naidu, that you have chosen to take an oath. I think the document is before you there. If I could just read the one line, if you could just repeat after me, and then thereafter take the oath. I swear by Almighty God
You want me to repeat after you, Chairman? Right, ready.
I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence that I shall give
will be the truth,
will be the truth,
the whole truth, and nothing but the truth.
and nothing but the truth.
Please say, so help me God. Pray there.
So help me God.
Thank you, sir. That have been dispensed with. We will get straight into the business of the day. Mr. Vanara, it is 10:25. If at all possible, sir, because we need to catch up time, can we allow you to do your business until 11 o'clock? After which we'll open up to members in very much the same fashion as yesterday. And just to be warned, Mr. Honorable Mokwena, you'll be the first one, so prepare yourself and we'll come all the way this way, and then the next will be the other way. Over to you, Mr. Vanara.
Thank you, Chairperson. Mr. Naidu, can you, for the record, state your full names?
Krish Naidoo.
Can you give the committee your academic background, please?
Well, I'm a admitted attorney, acting as a consultant now to the ANC, and I also hold a master's degrees in strategic studies.
You were until very recently a non-executive board member of the South African Broadcasting Corporation, is that correct?
That's correct.
I'm in possession of a statement, and I have placed it before you as well, a copy of same, dated the 8th of December.
That's correct, Chair. That is a statement that I've written out and submitted to the committee yesterday.
Okay. Can you, I see in your statement you deal with 5 issues. You deal with the board's legal incapacity to discharge its duties and taking binding decisions. You deal with the board's abdication of responsibility and management usurpation of the board's responsibility. The third issue dealing with is the unlawful removal of the 3 non-executive board members. The 4th point you deal with in your statement are the attempts by the minister, or the alleged attempts by the minister, the board to remove you as a member. The last one, the contract between the SABC and MultiChoice, correct?
That's correct, Chair.
Can you take the committee then through your presentation around these 5 issues?
Thank you very much. Chairman, I was a non-executive board member between September 2013 and October 2016. In that time, I was also a member of the Audit, Social and Ethics, Risk and Finance, Investment, Procurement and Technology Board subcommittees. I was also deployed by the board to be a trustee of the SABC Medical Schemes Board. Following my consultation in Johannesburg in October 2016 with Advocate Vanara, the evidence leader, at the inquiry, and the subsequent resignation of all non-executive board members, bar one, I wish to adduce evidence on the following matters under oath, which I've taken. 1, board's legal incapacity to discharge its duties and take binding decisions. In terms of the South African Broadcasting Act 4 of 1999, a quorum of 9 members is required to transact business on behalf of the corporation. At the moment, the SABC board has 1 non-executive board member and 3 executive board members who perform their duties in acting capacities. Based on the above, it is apparent that the board does not have the legal capacity to discharge its fiduciary duties, adhere to the board charter and control the affairs of the corporation and carry out its duties as contemplated in terms of Section 13, subsection 11 of the Act. That's the SABC Act. On this legal interpretation alone, absent a long drawn-out inquiry, I hold the view that the National Assembly may invoke the provisions of Section 15, capital A, subsection 1, subsection B of the Act, and recommend the dissolution of the board because the board is not in a position to discharge its fiduciary duties, adhere to the charter, and control the affairs of the corporation due to legal incapacity. Point 2, board's abdication of responsibility and management's usurpation of board responsibility. Generally, the dysfunctionality of a board can arise from one of 2 sources, Chairman. The abdication of a board of its responsibility or the usurpation by management of the board's responsibility. Abdication occurs where board members, out of laziness, tardiness, or other reason, neglect their fiduciary duties and substantially allow management to run the corporation. Usurpation occurs where management takes over responsibilities which properly lie within the domain of the board. In both instances, good corporate governance suffers. In the SABC, we had a curious cocktail of both abdication and usurpation brought about by an immoral and clandestine relationship between some non-executive board members and executive board members, and which was managed by a simple majority. This immoral relationship led to the creation of 2 groups at board level. One which was concerned with discharging their fiduciary duties, and the other which was intent on achieving certain outcomes which are not necessarily in the best interest of the corporation. This unhealthy relationship placed Mr. Hlaudi Motsoeneng as a ringmaster and left me with one burning question which I have not been able to answer to this day. Why were so many educated professionals so beholden to a high school dropout? The dysfunctionality located itself along this parallel and manifested itself strictly along this parallel. At times, it got so bad that even if one argued about the time of day, which could have been verified by a number of objective sources, the outcome would invariably be that which the Hlaudi group wanted. My protestation to bring a semblance of sanity to the board fell on deaf ears. For instance, on 9 February 2015, I requested the chairperson, Professor Maguve, to convene a special board meeting based on a letter written to the board by Mr. Gavin Davis, a member of Parliament. In that letter, Mr. Davis raised the issue of that the amended Memorandum of Incorporation was ultra vires the Act, the Companies Act, and the Constitution. I informed the chairperson that these issues were new to me. No meeting was called. On 29 April 2015, and in furtherance of my concern that the memorandum of incorporation could be ultra vires the Act and therefore unlawful, I brought to the attention of the company secretary, Ms. Teresa Caldenes, some information I had gathered about the distinction between laws of specific application and laws of general application, and requested her to obtain a legal opinion from the SABC's legal department. Nothing was done. The appointment of Hlaudi Motsoeneng in July 2014 as Chief Operating Officer is probably the best example where the curious cocktail between the non-executive and executive board members, aided and abetted by the Honourable Minister, was mixed. The facts are well known. I voted against the appointment of Hlaudi. The manner in which the board dealt with the Public Protector's report left one in no doubt that the board had no respect for good corporate governance, a Chapter 9 institution, and the Constitution and Parliament. Ms. Ellen Shabalala, the previous board chairperson, was a primary driver of this morass of dysfunctionality. Her conduct bordered on criminality. On 27 September 2016, and after witnessing the appointment of Hlaudi Motsoeneng as Group Executive for Corporate Affairs on television, I wrote to the company secretary to impress upon the chairperson the need to convene an urgent board meeting. I received a negative response from Ms. Caldenes about 2 hours before the board was due to meet the Parliamentary Portfolio Committee on Communications on 5th October 2016 in this room. One could go on citing other serious breaches of governance, but in a nutshell, this is where the board went astray and why I believe it was dysfunctional. To enable the Hlaudi Group to manage the affairs of the corporation on a simple majority, some non-executive board members were removed unlawfully, and two unsuccessful attempts were made to remove me as a board member. Point 3, the unlawful removal of 3 non-executive board members. In my view, the late Hope Zinde, Ronnie Lubisi, and Rachel Kalidas were removed as board members on frivolous and unlawful grounds. The late Hope Zinde attended an ANC workshop on communications. 3 other board members, Ms. Imlakaza, Dr. Shizumba, and I attended that workshop and participated in the deliberations. Ms. Zinde was charged for divulging SABC information to a third party without consent, and on a simple majority vote of the board proposed by the chairperson, Professor Maguve, she was removed as a board member. Mr. Ronnie Lubisi was charged for having a conflict of interest for being the named auditor of 2 companies which did business with the SABC. Despite my explanation of what constituted a conflict of interest and Mr. Lubisi's protestation that he did not do any business with these companies, besides registering them, he was removed as a board member on a simple majority vote of the board proposed by the chairperson, Professor Maguve. Ms. Kalidas was charged with fraud for having left an audit committee meeting early to catch a flight, whereas it was subsequently established that she did not fly out that day. Once again, she was removed as a board member on a simple majority vote of the board proposed by the chairperson, Professor Maguve. Point 4, attempts by the minister and the board to remove me as a member. 2 attempts were made to remove me as a board member. The first was by the Minister of Communications in January 2015. I was summoned to a meeting with the minister one evening. The minister was not available to meet me, and 2 of her employees conducted the meeting. I was told that I did not attend meetings and I was disruptive in meetings. I told him I was convinced that the information presented to me was incorrect, but if the minister persisted, I would tender my resignation. Whilst driving home, the minister called to apologize, to tell me that I was an asset to the board and should not even contemplate resigning. A few days later, I received a letter from the very same minister asking to show cause why I should not be removed as a board member for failing to discharge my fiduciary duties. I decided to respond in writing to the minister, telling her that her conduct bordered on illegality and that in law, no action could arise from a dishonorable cause. In short, I asked the Honorable Minister to reconsider her action. I never heard from her again. In my view, this was a classic example of a dysfunctional ministry which compounded the problems of a dysfunctional SABC board. Second attempt was by the board in September 2015, after an oversight visit to the SABC by the Parliamentary Portfolio Committee on Communications. The board chairperson, Professor Maguve, wanted to have me removed as a board member because I had raised the issue of the 3 dismissed board members with the PPC. In my written response, I said that my interaction was constructive, intra vires the Broadcasting Act, and within the expectation and contemplation of the shareholder. I never heard from the good professor again on my removal. For the contract between SABC and MultiChoice, prior to my appointment as a board member in September 2013, the interim board had signed a contract with MultiChoice, which drew widespread condemnation in the media. At the board meeting in October, many board members raised the issue of the contract with MultiChoice. It was also raised by board members with the then Minister Karim. The chairperson, Ms. Shabalala, acceded to my request that I consider the contract and provide the board with a legal opinion. At a subsequent meeting, I advised the board that the contract was unlawful and submitted reasons for arriving at this conclusion. The chairperson suggested that the board obtain a second opinion, which was subsequently done and which contradicted my opinion. After I made my input to the board, I received a call from Mr. Imtiaz Patel, the Group Chief Executive of MultiChoice. He wanted to congratulate me on my appointment. I obliged because he was an old friend. After some small talk, we went straight into the SABC MultiChoice contract, and he wanted to know what was the reasons for my opposition. Needless to say, I was shocked that the board was so leaky. Nonetheless, I gave him the reasons and suggested that the contract should be terminated and a new contract on more equitable terms should be concluded. He agreed with the proposition and said that the SABC MultiChoice contract was concluded very hastily. This contract and incident was the first stage that I was heading down a long and rocky road.
Thank you, Mr. Naidu. See, this inquiry has to be fair. We can't only focus on the alleged bad issues. Your statement also deals with some good things that took place at the corporation. Can you deal with those?
Thank you, Chair. Chair, not everything about the SABC is bad. I brought along a few meeting board packs to show the professionalism in which these are put together. Sometimes these packs are delivered to my home by SABC staff late at night. These qualities bear testimony to the hard work and dedication of SABC Secretariat. The staff of the SABC constitutes a rich tapestry of experience, knowledge, skill, talent, and institutional memory, and are a priceless national asset in our young democracy. What is required is to conjure up the political will, to do the right thing and place the SABC on a trajectory to enable it to deliver its basic outputs, to inform, educate, and entertain, and play a role in social cohesion and nation building. In that process, we can build a strong state-owned entity we can be proud of. Thank you.
Thank you, Mr. Naidu. In your statement in page 2, paragraph 3, you make a distinction between two groupings in the board. Who belonged to which grouping within the board?
Well, looking from the time of inception, let's go back to September 2013 under the chairpersonship of Ellen Shabalala. Well, she was certainly in the Schlaudi camp. I'm trying to think of, well, Dr. Shidzumba. Yeah, I think they, and of course the three executives, Schlaudi, Motsoneng, and others. But then the board dissipated quite quickly with the removal of board members, and it left just myself and Ronnie Lubisi was removed, Rachel Kalidas was removed. They were part of the group that were very serious about corporate governance and executing fiduciary duties at the board. And we were left, in the end, we were left with 9 board members, 6 non-executive, 3 executive, and it was just Mr. Mavuso and I that were trying to oppose everything. So, in a way, the outcome of votes were very predictable. It was always 7-2 in favor of the Schlaudi group.
The issue around the amendment of the Memorandum of Incorporation, you requested it be placed on the board agenda. And your response is that it was never done. Were you appraised of any reasons as to why this never happened?
Well, the amendments to the MOI was really initiated by the minister, and it seems that the intention was, one is to find an easier way to remove board members. And what I found very unusual about that MOI is that it relied on the Companies Act, Section 71 of the Companies Act, to remove board members. But unfortunately, the minister and her crew did not have the courage to put in a provision to admit board members, because if they had put in a simple provision of admitting board members in terms of the Companies Act, then they wouldn't be just left with 1 board member today. So the fallacy of that whole aspect, and I believe it's ultra vires, the Memorandum of Incorporation on this basis. You cannot substitute a law of specific application, which is the SA Broadcasting Act, with a law of general application. The SABC Act is very, very specific as to the role of the appointing authority for appointing board members and how board members are removed in terms of this inquiry like you're having today. So it's very specific, very detailed. Now, one can't take a simplistic approach, as is done in the MOI, to remove board members just by simple voting around the table.
My question is, were you given any reasons why this important document would not be a subject of a discussion by the board?
No, we were not given many reasons, except that this was driven mainly by the ministry, and I think with the company secretary who played a role in developing that document. And after I got sight of the document, sometime in July 2014, around there, I then made an input to the company secretary, giving an opinion. I did some research, and I picked up a case in the US, and I told her, look, we needed to research this because that dealt with why it would be unlawful to take a law of general application like the Companies Act and substitute it for a law of specific application like the SABC Broadcasting Act. In fact, nothing was done about that, as I said in my presentation. But that in itself, I thought, made the MOI unlawful. The second point is that it also affected the way executives were appointed in the corporation. I mean, there used to be a process in the past which required some kind of board intervention or approval or certification. But that has been taken away completely, so it became the function of the CEO and the COO to appoint executives. And what I found after the MOI became, law at SABC, you would attend meetings, and every meeting you'd find different people. So you ask yourself, what happened to Joe Soap who was here at the last meeting? Oh, he's either been suspended or left. So you had this large turnover of staff. They were either suspended or they left. And you had all these acting appointees holding very, very senior positions. Now that in itself is a factor which contributes to dysfunctionality.
I accept you hold strong legal views around the differences of interpretation. And I don't want us to spend too much time there because, as I understand, this matter is a subject of a litigation, is that correct?
It is the subject of litigation, yeah, by those board members that were removed.
I'm interested in your second last paragraph on page 2. You say the appointment of Hlaudi Motsoeneng in July 2014 as Chief Operating Officer is probably the best example where the curious cocktail between the non-executive and executive board members, aided and abated by the Honorable Minister, was mixed. What do you mean by this statement? And secondly,
Well,
who is the minister you're referring to here?
The minister on that date was Honorable Faith Mutambi. The unusual aspects, firstly, I mean, the board meeting took place late one evening, probably at about 6 or 7 o'clock. And I suppose that was done to accommodate some board members. But what made it even more unusual, apparently the minister was on the premises of the SABC. And it appeared that she had had a prior discussion with the chairperson at the time, Ellen Shabalala. So we had this board meeting and we were given a legal opinion by an attorney on behalf of Mr. Motsoeneng, who told us what a great chap he was and that he had been acting for far too long and there was a need to consider him as a permanent COO of the SABC. So that was the prelude to this discussion. There was some discussion. There was a lot of opposition from those who felt that due process was not being followed. But nonetheless, it led to a kind of split in the House, a narrow split by, I think it was a split vote of about 6 against 5. 6 in favor of his appointment and 5 against his appointment. After that simple decision was taken, the minister was brought in. She thanked the board for having considered that matter. That is a matter of appointing Mr. Motsoeneng as permanent COO of the SABC. She said she'll consider that recommendation because it went to her as a recommendation from the board. By that stage, it was about 11 o'clock that evening. And lo and behold, by 8 o'clock the next morning, she made a public announcement that Mr. Motsoeneng was the permanent COO of the SABC, so she probably considered it in her dreams.
At the bottom of that page 2, where you deal with the manner in which the board dealt with the public protector's report, you say it left one in no doubt that the board had no respect for good corporate governance. A Chapter 9 institution of the Constitution and Parliament. Those are very serious allegations. What do you mean by that?
Well, unbeknown to us as board members, the interim public protector's report was given to the chairperson, Ms. Ellen Shabalala, in November of about 2013. And this was not disclosed to the board. So when the final report came out in about February or March 2014, as a board, we were very concerned that we were not presented with an interim report, but a final report. It then emerged from the chairperson at the board meeting that, in fact, she was given the report 3 months previously, but because the letter was addressed to her, she thought it was for her personal consumption only and never disclosed it to the board, and I thought that was very, very amateurish in my view. But in the meantime, she had solicited the services of an attorney and she was busy processing a response to that report, basically in defense of herself and in defense of Hlaudi Motsoeneng. And it also transpired that in that interim period after she had received the report, she had actually made representations to the public protector before the final report was published. So the board had no input into that final report.
Ms. Shabalala was also a non-executive board member. She was not an executive chairperson. Is that correct?
That's correct.
Subsequent to Mr. Motsoeneng's appointment as group executive for corporate affairs on television. You wrote to the company secretary. What happened then?
Well, the reason I wrote to the company secretary is that about a week after, I think, the Supreme Court of Appeal made its decision, I made my input to the board, and my input simply was that that decision of the SEA effectively terminated the employment relationship between the SABC and Mr. Motsoneng. In other words, it was time to pack his bags, that decision in Bloemfontein. But it seems that the board, the executive group CEO, Mr. Gaguma, had gone on his own without broad approval, and based on the advice of some lawyer at the SABC, appointed Mr. Hlaudi Motsoneng as Chief Corporate Affairs, Head of Corporate Affairs. Now, in my view, that was unlawful. And I came to the conclusion that here we had somebody who had no right to be at a national key point. In fact, he was squatting at a national key point because that appointment was unlawful. So I thought it was appropriate for the board to meet. It was a serious issue, the board to meet and discuss it. But I didn't get a response. In fact, I got a response about 2 hours before our presentation to the Parliamentary Portfolio Committee on the 5th of October, which was about 8 or 9 days later. A negative response.
The last question from myself relates to the example of the Joe soap you referred to, the changing of faces of the executives for various reasons. But I want to link this to the MOI. My understanding is that the MOI, before it was amended, gave the board powers to oversee the appointment of executives. Is that correct?
That's correct.
And that this amended MOI took those powers from the board and gave them to the executives.
Yeah, it vested all those powers in the executives. In other words, changes could occur at a very senior level within the SABC without board knowledge.
Thank you, Chair, for that question.
Thank you very much, Mr. Vanara. Your 5 minutes starts now, Honorable Mokoena.
Thanks, Chair. Mr. Naidu, are you well? Let me just get straight to the point. Where's Hlaudi getting his power from?
I'm sorry?
Where is Mr. Hlaudi Motsoneng getting his power from?
I don't know. I mean, that's a question I've been asking myself, even in my presentation. You know, it's very unusual for any individual in a state-owned entity to behave in this particular manner. So either he's on a frolic of his own, or he's getting support by parties that I'm not aware of.
Okay. The amendment to the MOI, are you in concurrence with the belief that it was done solely by the minister without the consent of the board?
Well, it was done substantially by the minister and her team within the ministry, with some participation from the SABC Secretariat. That's my understanding.
But it would have been, it would need to be approved by the board.
Yeah,
and it wasn't.
but the board never participated in the development, other than copies being sent to us from time to time. We raised our objections and made our protestations, but in the end, it was passed.
Do you have the letter in which you advised the minister that the MOI was illegally constituted, the amendments?
Yeah, I've got a copy of a short opinion that I sent to the company secretary, which I will make available to the committee.
And then the public protector's report, do you have evidence that the minister was advised that the appointment of Mr. Motsoneng was in contradiction of the public protector's report and therefore illegal?
When you mean the minister was advised, at what point would the minister be advised?
Well, what was she not advised? What was she not advised that the process that took place in order to instate Mr. Hlaudi was illegal? In terms of the report, was she not advised as to that fact?
No, there was, well, two things, I think. First is, at the time the appointment was made, the public protector's report was made public. So the minister would have had an obligation to take cognizance of that fact. And the fact that the person that she was seeking to appoint was damned in that report, was subject to a whole lot of investigations, and the recommendation in that report was this particular individual should go through a process of a disciplinary inquiry. So the question then becomes that was it a proper appointment? Was that a considered appointment? Did the minister apply her mind properly to that appointment? And that's why the Western Cape High Court and the Supreme Court of Appeal made the finding that this appointment was made without proper application of one's mind.
Okay, no, that's fine. Okay, then the executive then appointed him as the group corporate executive.
You're talking about corporate executive or CEO?
No. I was talking about CEO
okay,
then. I'm now talking about the...
in September 2016.
Yeah. Was the board advised... was there a board meeting that happened? Was the board advised of the decision to reinstate him in another position? And was the minister advised on the illegality of that appointment?
Well, as a board member at the time, I read about that appointment in the newspapers. I saw it on television, sorry, that Mr. Matsuneng was appointed as group chief executive, and that prompted me to write this letter to the company secretary for the attention of the chairperson, because in my view, that was an unlawful appointment.
But in light of the fact that the MOI was then amended, is that MOI, the amendments to the MOI, what gave the powers to the executive to then reappoint him at a lower...
Notwithstanding the appointment of the MOI, the appointment of Mr. Matsuneng was unlawful, firstly by virtue of the SCA decision. That decision was the trigger that said this person had no place at the SABC.
Unfortunately, my dear friend, Injal.
I had the last one.
Injal, Mr. Mhlangu, Honorable.
Chair, thank you. Mr. Naidu, let me start at the end. The multi-choice contract, you have a problem with it. Is this emanating out of your fiduciary responsibility to SABC, or because the media had queried that question?
Well, Chairperson, at the time we joined the board in September 2013, there was this huge media rage about this particular contract. So as part of my fiduciary duties, I offered the chairperson at the time my services as an attorney, and I said, look, let me have a look at it. So I think I was the only board member that really saw that contract. No other board member saw it. So I went through it, drew up a written opinion, gave it to the board, and then I got this call from MultiChoice, and I went across, and and for the reasons, I mean, I can go into the detail, but I don't think this is the relevant stage to do it.
Okay.
But it was clearly an unlawful contract, and it's something that should not have been signed, in my view.
Okay. The next question: the meeting that you had in January 2015, who convened the meeting? Who summoned you to the meeting?
The meeting with the minister, the minister.
Yeah. Was it the minister?
The minister was holding one-to-one, meetings with various board members. And my meeting was set for, I think, 7 o'clock that evening at the office in Pretoria.
But you then met the minister's staff?
Yeah, when I got there, the minister had just popped across to see the president. And so the meeting was started by the minister's advisor and some other gentleman from her department.
You know the people or you don't?
I know the one person. He was the advisor at the time, Dan, forgot his surname, Mancha. Dan Mancha, I think. Yeah, I don't know who the other gentleman was.
According to you as a board member, do you consider the minister as an internal player or an external?
I think, well, the minister, generally, the role of the minister would be one of political oversight. I just think that the minister came a bit too close to the action at the SABC.
The role of the company secretary, especially in the matters that you have raised as...
I think that the company secretary could have done a lot more to give proper guidance to the board. You know, a company secretary is somebody, in her case, she was a chartered accountant, but a company secretary also has to give some kind of legal guidance on procedure. Now, you know, when as a board member you write to the company secretary and say, please bring this matter to the attention of the chair, because it's only the chair and the deputy chair in terms of the act that can convene board meetings. We don't have powers to call board meetings. So we have to submit it to the company secretary, who then brings it to the attention of the chair. Now, I thought that the company secretary should have realized the import of some of the issues that were going around without proper discussion, without proper investigation. For example, the appointment of Mr. Motsoeneng as Group Chief Corporate Affairs Officer, that was a serious matter which warranted a meeting. Now, a company secretary should implore upon the chairperson, who is not a lawyer, who does not have legal experience, and probably even less experience as chairperson in terms of good corporate governance, should advise that gentleman that, look, I think this is sufficiently serious to warrant a meeting. Now, that's where the company secretary came short, in my view, on many instances.
Chair, soon my time is over.
Now you got a minute, sir.
Oh, thank you. Wait. Now, as a member of the risk committee, did you often review, King 3 directs that board members should at least review the risk profile, risk policy, and what have you, annually. Were you doing it over your period in the SABC?
The risk committee met regularly, quarterly. In fact, we met every 3 months, and we did a very thorough analysis of the risk facing the corporation. All the risks, not just financial, physical risks, technology, risks in technology.
I want to then assume that the things that have been raised here as red flags would have been contained in your risk analysis profile.
Depending what things,
Well, the things that we're talking about, your multi-choice, your minister's interference, your secretariat ability.
We didn't deal with those elements of risk. The multi-choice, if you recall, was dealt with right at the outset in September 2013. The minister's role within the SABC is not something that would ordinarily fall within the ambit of the risk committee. We had terms of reference for the various subcommittees, and that did not fall within the terms of reference.
Thank you so much, Mr. Naidu. Can we move over to Honorable Van Dam?
Thanks, Chair. Mr. Naidu, so I just want you to talk to me through, So on the 20th of September 2016, the SCA denies Mr. Motsoeneng leave to appeal, which means he must pack his bags. 2 days later, there's a draft resolution circulated to all board members requesting that he be appointed as acting COO. And then on 27 September, he's instead appointed as GE Corporate Affairs. What happened between the 22nd of September and the 27th of September?
I'm not aware of, nothing has happened in my view as a non-executive board member, but I can only piece together what happened after the fact. Some of us, in my speaking for myself, I disapproved of that round robin resolution to appoint him, and in my comment section on the round robin document, I stated why. Because it would have been unlawful to appoint him pursuant to the SCA decision. The minister, normally these round robin resolutions go to the minister in the case of Mr. Motsoeneng because he's one of the 3 executives. And I think the minister was persuaded by that argument, and she did not appoint him as COO. And then it was up to James Aguma, who was acting CEO, who then took it upon himself on the advice, as he says, on the advice of the lawyer of the SABC to appoint him as head of corporate affairs. So that's how it came about. So that's what happened between those 5 days.
Yes, the GE Corporate Affairs position was not approved by the board, am I correct?
No.
Yes. And then Ms. Bessie Tungwana's appointment instead as acting COO, was that approved by the board?
No, I mean, I only realized she was the acting CEO when I met her here on the 5th of October.
So that would have not been approved by the board?
Now, ordinarily, it should have been approved by the board or gone to the minister as a recommendation from the board, but it never came through the board.
Okay, so who would have approved that appointment then? Would have to be the minister?
The minister would make the final appointment acting on the recommendation of the board.
Okay, so since there was no board approval, one could then say that it was a decision taken by the minister without approval from the board.
Well, I'm not even sure whether the minister approved that appointment, because my understanding is that because the board had not made the recommendation, Mr. Kwana's calling herself the COO was unlawful. You know, so even if the minister appointed her, it would have been an unlawful appointment.
But, I mean, because so one of the witnesses said yesterday, the minister is a lawyer, she's aware of the legislative requirements. She should have known that she cannot approve an appointment which hasn't been approved by the board, am I correct?
Yeah, and it's not difficult to remember that there's just 3 top executives at the SABC. We're not dealing with 3,000 people.
Yeah.
Now, it's simple to remember as a minister that these 3 people, there's a due process. They must be considered by the board, recommended to me, and then I apply my mind. So it's not difficult for the minister to remember that.
So that appointment would essentially be unlawful?
It is unlawful.
All right. The draft resolution on the 22nd of September, who would have been that source of that draft resolution?
Well, I've got a copy here. Normally the resolutions are put out by the company secretary, Ms. Caldenes.
On instruction of?
Presumably on the instruction of the chairperson.
All right. One more question, Chair, if I've still got time. On the 1st of August 2016, Mr. Motsoeneng announced publicly that he had decided to give 50,000 each to 180 local musicians. Would that been a decision which would have
Well, if he
been
gave
approved
it out
by
of
the
his
board?
own pocket, that's fine. I don't have a problem. But if it's SABC funds, then it never came through the board.
It was SABC funds, so that
Oh,
was
well,
not.
then it wasn't approved by the board.
Are you aware of any other decisions taken by Mr. Motsoeneng which would have required board approval that didn't have
I mean,
board approval?
I remember there was this controversial decision about local content. You know, Mr. Motsoeneng decided that there must be 90% local content so that more money can flow to local artists. The sentiment was fine, but the manner in which he went about it was wrong, in my view.
Thank you so much, sir. And ma'am, could we move over to the Honorable Khoza?
Thank you, Chair. First of all, let me probably start by imploring on you, Mr. Naidu, to be as brutally honest with us as possible and be frank with us, because the intention is to restore good governance at SABC and ultimately to all the state-owned enterprises. Having said that, Chair, sir, as a lawyer, would you concede that there had then no been political interference? Mr. Motsoeneng would not have been appointed either as COO or GE Corporate Affairs.
Well, you know, to get appointed at that level would require some kind of political intervention, assuming one follows due process. Ultimately, the minister has to confirm the appointment of those people. Now, if they were appointed absent due process, then that's political interference.
Thank you. Would you probably identify other political key players other than the minister that you think might have played a role in this process?
Well, I think, I was quite surprised by the views of the previous Parliamentary Portfolio Committee regarding the 3 non-executive board members that were dismissed. It was clear as daylight that was unlawful. But for some strange reason, that Portfolio Committee took the view that it was lawful. So, how does ordinary sane members of Parliament come to that conclusion? So that was a bit startling.
So are you suggesting that the Portfolio Committee also played a role, the Portfolio Committee on Communication played a role somehow?
Well, unless, if it wasn't a political intervention, then they probably were not clued up on the law.
Okay, thank you, sir. Could you kindly identify, earlier on you alluded to the fact that there were 3 points of contention with the multi-choice contract. Could you identify at least the 3 in their chronological sequencing, according to you?
In that particular contract?
Yep.
I can give you the main point of contention, because
Okay.
I think it might be a bit awry of me to now go into commercial confidentiality issues. But the thing
We won't
that's
allow you to do that. The role of the board is fine if you went to that one, but we don't want to get the nitty-gritty of...
Okay, but I can just give the main issue in that contract that raised a flag for me as a practitioner is that contract purportedly was an agreement by MultiChoice to use archival material of the SABC. I mean, that was the basis of that contract, but it was made subject, the entire contract or the payment to SABC of that, under that contract was made subject to the condition that the SABC will adopt a particular position on a set-top control. Now, I found that very, very strange and totally unrelated. And that's why that contract was unlawful. Secondly, of course, the person that signed it had no authority to sign that contract.
Thank you, sir. I just want to ask you something that has got to do with the retrogression of the financial, the audit opinion by the Auditor General and the irregular expenditure. As you know, you came from 3.4 billion in almost 3.4 billion in 2013, 2014, 2015. You improved it drastically. But then 2015, 2016, you started going back to, almost going back to where you were. What do you think are the key main factors that are leading to this state of, retrogression?
Well, the factors given to us by the executives of the SABC was that there was a downturn in the economy, so that there was less income on advertising revenue. So, I mean, that was a fair point to make. That led to the retrogression you speak of, Honourable Member. Secondly, there was a write-down of license fees. We had about 2 billion rand of unpaid, uncollected license fees. And these things were outstanding for a very long time. And the debate was the question of prescription. Does it prescribe after 3 years, or does it follow the state rule of 15 to 30 years? That debate went on for a year. And this year we resolved that it was a 3-year prescription. So we had to write down about 2 million rand of, we had to write off 2 million rand of license fees.
2 million or 2 billion?
2 billion, sorry, 2
Okay.
billion. And then there were certain other issues concerning the VAT. There was this debate between SABC and SARS on when do you charge VAT when you pay license with SABC. Is it at the time you issue the license? Is it on accrual or on invoice? And Mr. Motsoneng and the group CEO, Mr. Aguma, spent a fair amount of time and achieved a measure of success, in my view, in trying to resolve that dispute, although it's still unresolved. So these factors taken together led to a retrogression in the financials.
Thank you very much.
Okay, thank you, sir.
The Honourable Oliver.
Thanks. Sorry. Thanks, Chair. I'm partially covered by my colleagues, except for 2 areas that I need clarity on, Mr. Naidu. The first one is to say, You sat in about 5 subcommittees at the SABC. And those subcommittees are supposed to have resolutions that are taking the institution forward. What impact did resolutions of all the committees you sat on had on the running of the institution?
I think the subcommittees were well run. They were the debates were very good in the subcommittees, and the resolutions were good, all directed at benefiting and furthering the interests of the organization. The dysfunctionality came in how in the two camps, so to speak. So, in other words, one can't fault the functioning of the subcommittee, which led to dysfunctionality. I think the dysfunctionality came in the manner in which certain non-executive board members, together with certain executive board members, took decisions in the corporation.
Are you in a way indicating that there were good resolutions which never saw light in terms of implementation?
No, the subcommittee resolutions were mainly there to support the organization. For example, on the audit committee, which I sat on as a member, we looked at the past problems in the corporation, how we could resolve them. Like, for example, writing up an asset register, which didn't exist in the past. So it was all developmental issues leading to a better SABC.
And the last one is, when you received a letter or when you responded to the chairperson when he wanted to take you out of the board, did you respond in Braille?
Then I responded in normal English, in writing. Yeah.
Thank you very much.
Maybe that's why he didn't get back to me. He didn't see it.
You done, ma'am? You done? Honorable Killer?
Chairperson, thank you. I would like to ask Mr. Naidu, first of all, when you started, was there any induction program for new board members? And were you sort of everybody brought on par as far as the legislative framework is concerned? And that includes that at that stage, the memorandum of incorporation.
Yeah, I think that was one of the shortcomings, and I know that the company secretary complained very bitterly about the fact that the board members were not properly inducted into the organization. And the reason being that when we were appointed as board members, there were several issues consuming the organization, so we had to get straight into the issues. I mean, the SABC multi-choice deal, and then in the next year we had the whole Schlaudi Motsoeneng appointment issue. So I think that was a major failing. We should have been properly inducted, and perhaps we could have added much more as board members to help the corporation.
Thank you, Mr. Naidu. Secondly, you see, that is part of the problem as from our perspective, is clearly there were individuals driving from the chair position, as sort of an executive chair position, whereas it was very much an organization based on board decision making. So that also contributed to dysfunctionality. Secondly, I would like to come back to the amendments of the MOI. When were you made aware, and is that not a board function to adjust the memorandum of incorporation? We have 2 copies of different ones. One signed in October 2014 and the other one signed somewhere in 2016. Are you aware of those? Have you received it? Were it discussed? Any of those documents, were they discussed?
We received draft copies of the MI from time to time. You know, there were several amendments being made to it. And I think around 2014 or 2015, I can't remember the date, it was subsequently approved. But the problem with the MOI, it was done, I think, in contravention, in my view, of the Broadcasting Corporation Act, to some extent the constitution of the country. So when you start amending documents like the MOI, and you don't take due cognizance of the legal framework in which that MOI should have been drawn, that's where the problem started, in my view. And that's why I believe it's ultra vires the act.
You, as a lawyer, and clearly it should have been a very difficult process for you to belong in a board as a legal person. Did you at any stage put anything in writing apart from alerting the company secretary? Did you present any document to the board? Did you say, this is ultra vires, we cannot go on like this is against the Broadcasting Act, etc.? Or did you not have such an opportunity?
Now, I've written about 3 or 4 letters to the board through the company secretary, offering legal advice. I mean, that was my expertise. And that's why I joined the board in the first place, because I was told when I was recommended to join this board that this board needs some legal advice. So please, consider applying, and which I did, and I was appointed. So my expertise was to help a board that had problems at the time of the appointment, but needed advice. So we went in with good intentions, thinking that, with our little expertise, we could make it a better SABC.
Then the Public Protector report, when that was released, it was in fact shortly after you became a member of the board. And subsequent events then turned out that a person that was accused of, well, the Public Protector's comment here is saying, allegation that Mr. Motsweneng committed fraud is substantiated. Did you at any stage during the meeting where he was appointed in July, did you at any stage raise that issue? Did you put it in writing to say that we cannot endorse this because of the findings of the Public Protector and that the board will be remiss in its duty? Because that also is flying in the face of the Memorandum of Incorporation, by the way, which was the reigning one at that particular stage.
Well, the whole basis of the opposition to Mr. Motsweneng be appointed as CEO was the Public Protector's report. How does one appoint a person into a senior position in a corporation like the SABC in the light of all of these damning findings? So there had to be due process first. Beside his his educational qualifications did not warrant that he be given that job in the first place, notwithstanding the Public Protector's report. But put that aside, the educational qualification and the fact that there were so many clouds around him required some kind of process, due process, to clarify issues before he should be considered. So I think he had an incapacity from 2 points of view. One is he lacked the educational qualifications to warrant appointment as a COO, number one. Number two is, with all these clouds around him, it had to be cleared before he could be considered for appointment. And I think any rational person in the position of the minister should have taken that into account.
Thank
Last
you very
question.
much. No, thank you very much. Honorable Chauke.
No, thank you very much, Chair. Mr. Naidu, when did you resign yes, as a board member?
On the 5th of October 2016.
Where?
Where?
Yes.
When I made a presentation to the Portfolio Committee, Parliamentary Portfolio Committee.
Why did you take a decision that day when you were in Parliament, to resign in Parliament?
No, I took a decision well before that. I just thought it was a nice platform to announce it.
Can you elaborate on your presentation on page 3, the top paragraph that deals with Eden Chabalala as a driver of dysfunctioning of the board and their conduct bordered on the criminality? Can you just elaborate on that part?
Yeah, you see, Ms. Shabalala, it subsequently came to our knowledge, had a copy of the interim report in November of the previous year. It was not disclosed to the board. Now, when you look at fiduciary duties of board members, there are 4 things. 1, you have a duty of good faith. You have a duty to act loyally. You have a duty to disclose information. You see, so when you don't disclose information, and if you have regard to the King rules around governance, and even the amendments to the Companies Act since 2008, if you act in a particular way, contrary to the fiduciary responsibilities of a director, which we were on the SABC board, you could attract criminal liability. That's the law.
So what did you do about that when you discovered these abnormalities?
Well, what did I do at that stage? Well, of course, we were very upset with Ms. Shabalala that she didn't tell us about this. But of course, she then came across very naively saying that, well, I thought it was addressed to me personally, so that's why I didn't disclose it to you. Now, either she was being very honest with us, and she was naive, or she was being dishonest. I couldn't make out the distinction there.
Now, let's go back to the report of the public protector and the position of the board to deal with the findings of the public protector. And what is your position there? Because you've been a member of the board that dragged, in fact, you arrived at the time when the report was then tabled. And I thought that was the time that you'll have jumped ship when you realize that, in fact, these people are just breaking the law. What is your view on that? And come again on the issue of judicial review. Was there any discussion in the board to take such a decision, or a resolution of the board to take such a decision?
It was recommended to the board that when you are dealing with the public report of the public protector, you really have two options. One is to accept the findings. Two is to take it on court on judicial review if you're not happy with the findings. That proposition was put to Ms. Shabalala, but instead she chose the option of justifying, creating a justification to show that these findings were not correct. Now, that's not an option. So I think she chose the wrong route.
And what was your position then?
My position was that this matter should have been taken on review, but it was not accepted by the board.
Dealing with the risk and internal audit, the almost 5.1 billion regular expenditure, which include fruitless and wasteful expenditure. What is your position, and what is it that must happen moving forward, dealing with such a finding of the Auditor General? With your understanding of yourself, PFMA, that deals with maybe without really putting forward the issue of investigation, recovery, and action. I want you to speak on those.
Yeah, I think when one has regard to the unlawful or unaccounted for expenditure by the SABC, one must understand the nature of the animal here. The SABC, sometimes things happen, and the SABC then forced to televise certain events of national importance live, and in that time there's no time to go through the due process. So what I think the way to rectify that is to have a kind of interim process where you can have due process but in a kind of short form. For example, if you look at in the PFMA, you're allowed to do contracting in terms of Section 32 of the supply chain management. In other words, you can have a shorter form of process but ensure that it is due process and not allowing any room for untoward expenditure. So I think there's room or need for improvement in that regard in respect of the SABC, because from time to time they are called upon by government to cover certain events which are not really part of their budget, which is not budgeted for. And I think because of a lack of a paper trail, because of the urgency of situations, it comes up as an audit query.
And then what?
Thank you, sir. Thanks, Mr. Chauke.
Okay, thank you.
Mr. Naidu, thank you very much, sir, for availing yourself and for cooperating with the committee in its work. The last thing that I just want to say is that you'll appreciate that we couldn't do or say or ask all the questions that we needed to ask because we're limited by time. However, if there's anything that you subsequently realize is important for this committee, our doors are always open. You can drop a note to Cindy or request some sort of communication, and we will gladly take that and consider it in our final report. So once again, thank you very much, sir, and have a good weekend. After 2 minutes, I see that the next witness, Mr. Molefe, is here, so we'll have about 2 minutes just to catch a deep breath, and then we'll go on to Mr. Molefe. Thank you very much, sir. And you can have,
Can
are you
I-
giving these
No,
documents
no, I'm
to us?
handing this into the
Oh,
committee.
thank you. Thank you very much, sir. No, man. Is it tea break now?
We can better go breakfast.
Sir, you can join us for tea if you want to. We're just checking if the tea is available.
Chair,
We're just checking that now.
can I also suggest that the tea comes with cake?
Mr. Chowke the other day said this is not a place of muffins and whatever. So don't talk about cake.
Well, that's the SABC inquiry continuing in Parliament. Now, we'll keep you abreast of the happenings there.
All right. Honorable members, we want to start or we want to proceed? Honorable members, the next witness the next witness to assist us in our information gathering is Mr. P. Molefe. He's a former acting CEO of the SABC. Mr. Molefe, welcome, and thanks for availing yourself and also providing us with a statement. It is my duty, sir, to inform you that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that the evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. I'm informed that you have had sight of that and that you are prepared to take an oath. Is that it, sir? If you are, could you just repeat after me? I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Will be the truth.
Will be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Please say, so help me God.
So help me God.
Thank you very much, sir. It is Advocate 20-12. Can we ask you to try and conclude your business by about 10 past 12, sir, if possible?
No, thanks, Chair. Just before I proceed, there is a statement that Mr. Molefe has made. I was under the impression that it was circulated to members, but the members indicate that, or some of them say they haven't received it. If we can just spend some time to distribute it, it will still be fine within the time given to finalize the presentation.
I was under Kendall. How many members have not received it? I apologize for that. And whilst we're doing that, can I request or ask our staff that when proceedings are in process, that we do not walk in between the speaker, please. Rather walk or stay outside. It really makes for bad viewing for the public. I'm asking everybody, when proceedings are underway, that we try and maintain the decorum of this meeting. Honorable Mathango.
I wanted to raise exactly that matter, that when proceedings are on between the chair and whoever is participating, the rule of Parliament does not allow the crossing of the line. So that's an issue I wanted to raise. I'm happy you dealt with it. Thank you.
Okay, let's start, Mr. Molefe. Can you please, for the record, state your full names?
My full names are Thabo Philip Molefe.
You share with the committee your academic background?
My qualifications are postgraduate degree in management from the University of the Witwatersrand, and currently I am studying towards my master's degree with the University of South Africa.
Thank you. You made a statement. That statement is a 4-page document dated the 7th of December 2016. Is that correct?
That's correct.
That statement is before you.
Yes, indeed.
Without interruption, I'll give you an opportunity to go through that statement as a way of presentation. Over to you, sir.
Thank you, Advocate Vanara, and thank you, Chairperson and members of the committee. My statement starts with a background, and above it, it states my name and the designation that I held at the time, former acting group CEO of the SABC from July 2011 to January 2012. Background, I was employed at the South African Broadcasting Corporation for almost 20 years, from the 1st of March 1994 to 31 May 2013. During this period, I held several senior editorial and executive positions in the corporation. These included political editor, head of television news, editor-in-chief of radio and television news, head of SABC Africa, head of international affairs, group executive news and current affairs, and lastly, acting group chief executive officer. My statement, Chairperson, covers mainly the period July 2011 to January 2012, when I served as acting group CEO. This submission provides a historical context of the gradual erosion of governance and ethics, as well as the collapse of systems and processes in the SABC. The total disregard for processes and good governance was characterized by irregular appointments and highly questionable decisions. Serving on the board, the appointment as acting group CEO also meant sitting on the board as executive director. At the time, the board of the SABC was made up of 15 members, 12 non-executive directors, and 3 executive directors, namely the group CEO, the chief financial officer, and the chief operations officer, COO. At the time of my appointment, the positions of CFO and the COO were not filled with permanent appointments. The CFO was acting, and the COO position was not filled at all, either permanently or in an acting capacity. The first thing that struck me when I attended my first board meeting was to find that a member of staff who was neither CFO nor COO was allowed to sit in meetings as a board member. This member of staff is Hlaudi Motswening, who at the time had just been appointed group executive, stakeholder relations, and provinces, barely 3 months in the new position. This was a glaring aberration from the norms and the standards of the board to have a staff member other than the appointed executive directors sitting in board meetings. I raised this matter with the chairman of the board, Dr. Ben Ngubane, who said to me that Mr. Motsoeneng was sitting in board meetings at the invitation of the board. The Motsoeneng issue was raised again in a subsequent board meeting by a board member, Advocate Awe Mahlati, who wanted to know why Mr. Motsoeneng was allowed to sit in board meetings. This time around, the chairman of the board changed the tune and said Mr. Motsoeneng was participating in board meetings at his invitation, as it was his prerogative to invite whoever he chose to invite. Acting in the absence of the group CEO, in October 2011, I traveled to Seychelles to attend the General Assembly of the Southern African Broadcasting Association, SABA, which is the SADC version of broadcasting, and attended by heads of broadcasting corporations. I appointed a senior member of the group executive, Mr. Anton Hienes, to act as group CEO in my absence in terms of the delegation of authority framework. In my view, everything was done properly and in accordance with the DAF requirements. In fact, I had put forward 2 names for acting in my absence, namely Ms. Charlotte Mampane and Mr. Hienes, but Ms. Mampane was ostensibly rejected by the board. On my return, however, the chairman of the board, Dr. Ngubane, was not happy with the delegation of Mr. Hienes either, suggesting that Mr. Motsoeneng should have been appointed acting group CEO instead. I was then advised that in future I should leave this matter to the board to decide who must act in the event of my absence. The following month, in November 2011, I had to travel to Ghana for the African Union chapter of broadcasting, which is the African Union of Broadcasting, of which I was also a member of the Executive Council. On this occasion, I handed the delegation of authority back to the chairman of the board, who in turn would decide who to appoint to act in my absence. I tried in vain to establish who was going to act while I was away, but the decision was made only after I had left the country. On my arrival in Accra, the capital of Ghana, I received an email from my office informing me that Mr. Motsoeneng had been appointed acting group CEO with effect from 14th November 2011. This came as a shock to me because I had advised against the consideration of Mr. Motsoeneng to serve as acting group CEO while there were very senior group executive members such as Ms. Mampane and Mr. Hienes, among others. The view I held was that Mr. Motsoeneng was very junior and grossly inexperienced to be charged with such an enormous responsibility. To add to this shock, Dr. Ngubane appointed Mr. Motswening to the position of Acting Chief Operations Officer, COO, the following day after the appointment as Group CEO, and that was on the 15th of November, with effect from 18th November 2011, just a day after assuming the role of Acting Group CEO. All these critical appointments were made without the knowledge of the Acting Group CEO, as I was away on official business. The only conclusion one could draw from these hastily announced appointments within a day of each other was that this was pushed through in haste because I was vehemently opposed to the elevation of Mr. Motswening to such a senior position. Salary increment, 500,000 rand. In late November, Mr. Motswening approached me asking for a salary increment. I refused, and I also pointed out to him that his salary increment was in any case a board decision. Subsequently, Dr. Ngubane called me to his SABC office in early December 2011. When I came into his office, I found Mr. Motswening also present. The chairman then offered me a prepared letter recommending a 500,000 salary increment for Mr. Motswening. Dr. Ngubane asked me to sign the letter in order for him to approve the recommendation. I refused to sign the letter. I told Dr. Ngubane that in no uncertain terms would I agree to that demand. He tried to persuade me, but I stood my ground. And at this point, Mr. Motswening stepped in and said, open quote, "Chair, I told you that this is not our man, so I am going to Pretoria tonight," close quote. Dr. Ngubane pleaded with me, saying, open quote, "Please sign this thing so that we settle this matter," end quote. I refused, nevertheless. This chairperson happened at the time when the process of appointing a permanent group CEO was already underway. I had applied for the position, and the advertisement for applications had closed on December 2, before that meeting took place. And the matter was now in the hands of the board. TNA agreement. In another development, Mr. Motswening initiated a meeting in or about late July with one of the Gupta brothers because they were keen to, open quote, pursue a business partnership, close quote, with the SABC. Several meetings were held mainly with a Mr. Tony Gupta, and the discussions centered around, one, signing an MOU between the SABC and the TNA Media Group, in terms of which the SABC would allow TNA Media Group to have live broadcasts of its breakfast meetings on Morning Live. Two, agreeing to a huge subscription of the New Age newspapers to to be distributed in all SABC offices, national and across 9 provinces at a substantial cost to the corporation. 3, the Gupta Media Group also proposed having a stake in the then envisaged SABC News Channel. I did not agree to these proposals. These proposals, Chairperson, in my view, were quite drastic and with significant financial implications. I also did not agree with the proposal to cede a share of the envisaged SABC News Channel to an external partner. Such a move would, in any event, require board and ministerial approval. In the end, the position I took did not go down well with the Gupta brothers. Mr. Motswening tried to persuade me, urging me to soften my approach in dealing with the Guptas. I refused, pointing out that I would not make irregular and unjustifiable decisions. In conclusion, Chairperson, it was quite evident from the above that the erosion of governance and ethics, as well as the collapse of systems and processes, had started to take root in the SABC as far back as 2011. I thank you.
Thank you, Mr. Molefe. I am not going to ask you any further questions, but I would ask the committee to admit the statement as evidence, and I shall see. Thank you.
As pre-warned, Mr. Chauke, the floor is yours for 5 minutes.
Yeah, we're still preparing this time. We're like ambushed. No, but I think while I'm digesting, I can still start with the first question. No, Chair. Thank you very much, Ndate Molefe, for a detailed, shocking presentation you've just given to the committee. Obviously, I regard you as the founder members of SABC in a democratic society from 1994. And I think the country and everybody knows your role. And I'll take it that this presentation is informed by that rich history that we have. Now, the first question that I want to ask you is that when this engagement with the chairman of the board and with a prepared letter, approach you to sign an increment, and for me, what does this constitute? Was it not constitute criminality or fraud or corruption? What was your view, and what did you do with that when we approached with such an approach that constitutes something unwanted? I mean, that was more of crime that we caused to agree to. What is your position on that?
Well, my position was quite clear that this whole thing was irregular and it could not be justified. And that is why I did not agree to the demand that I should sign an approval for the increment of 500,000 rand.
Follow up to, what you have just said. The meeting to Pretoria, what did you understand by Mr. Taudi going to Pretoria? What was this Pretoria thing? What was your understanding? Or did you know he was going somewhere in Pretoria, either was going for, I don't know, maybe do you have any understanding of him saying that this man is not in our group, therefore I'm going to Pretoria?
Well, my understanding was going to Pretoria, it's going to a high authority. Although I did not in any specific terms have an idea what that authority in real terms represented, but it meant going to a high authority.
The last one, Chair, will be on the Gupta arrangement. Now that you then have left SABC, was that arrangement or that agreement carried through by SABC in your understanding now of things that you are not succumbing to? Have they gone through now with SABC, meaning that are they in operation?
Well, with regard to point one, I know that the SABC continued to have this arrangement with the TNA Media Group to carry the broadcast engagements live on their morning television broadcast show. With respect to the other 2 points that I alluded to, I don't know what happened to the distribution of the New Age at a subscription cost to the SABC. I don't know what could have happened subsequently. I do know, however, that, and that is with respect to point 3, that the SABC then proceeded to launch SABC News, which sits on channel 404, DSTV, and my understanding is that channel is exclusively run and owned by the SABC. And subsequently, the media group then established its own news channel, which sits on channel 405.
Was that a normal thing for the chairman of the board to always approach you with prepared letters for appointments or for increase?
That was actually the first time the chairperson of the board had approached me with an increase. We had never dealt with an increase at that level. So it was the first time that he had raised this matter about the Hlaudi Motsweneng salary increment.
Thank you very much. Honorable Kille.
Thank you, Chairperson. Chairperson, thank you very much. Can you just perhaps remember what was the amount of the deal? And we're talking about the TNA agreement. Could you remember in any way, because you said it was too expensive and, you know, a substantial cost to the corporation. Do you have any idea, can you remember perhaps what was the amount involved?
No, I don't quite remember, but the context to that whole approach was that at the time we were even considering to scale down on the number of newspapers that were distributed in the organization and in the newsrooms. In fact, I had even given a notice that newspapers should be circulated only to people who use newspapers as a tool of trade. But it was quite a costly amount, considering that you also had to carry the costs of other newspapers on a daily subscription arrangement.
Mr. Molefe, would you, if I read your statement, I read in between the lines that you actually allude to the fact that you have applied for the position of Group CEO, but that because you were not the man of a particular grouping, that do you believe that perhaps worked against your appointment to that? Because if we look at your history and your experience, clearly there was nobody to compete with you to assume the role of Group CEO. So you believe that played up against you and your position to, you know, to occupy that position on a permanent basis?
Absolutely, I agree that that worked against me, because even the timing when this demand was made to me, the demand was made to me at the time when the whole process of appointing a new Group CEO was underway. And it was quite evident to me that that would work against me. But I had chosen to err on the side of ethics and governance.
So basically with a gun against your head, but you stood firm. Now, just to go back to the appointment of Mr. Hlaude Motswaneng and his sudden sort of participation in board meetings. Can you perhaps tell us if you were aware of how his appointment came about? Who decided that? Was it a board decision? Was it formally done? Was there a restructuring? Or did he just appear and a post was created for him?
The one for group executive.
The one for stakeholder relations
Yes,
with
indeed.
provinces?
Yes. No. I know. The labor process where the unions would engage management and finally an increment is agreed at a certain percentage, which is then applied across the board. The second one would be a performance-related increment, which is like a special type of an increment which is accorded to someone who's performing exceptionally. At executive level, that would have to be taken to board and not be decided by a group CEO or indeed by a chairman of the board. A submission will have to be made to the full board to approve such an increment.
The last one is to say, when you left the institution, was it at your own accord or there were circumstances that led to your departure after you have served 20 years?
I was forcibly removed from the organization, and prematurely because I had still wanted to continue serving the organization and indeed serving South Africa. But I was literally removed from my job.
Thank you.
Honorable Khoza.
Chair, I just want to say to Mr. Molefe that I am a member of the African National Congress, and the reason why I am putting this on record is because I wanted to assure you that we want to restore good governance at SABC and ultimately in all the state-owned enterprises. And therefore, I would implore upon you to be honest when you are answering your questions as you have been, so that we can get to the root cause of these problems. Now, I know that my colleague Loliwe, as a former trade unionist, would have asked you the question whether you lodged a constructive dismissal with CCMA or whatever institution after you left SABC, or you just left it, and why did you leave that unattended?
Oh. No, in fact, my removal from the organization was preceded by a phantom process called a disciplinary process. And when the date was set for the hearing, the group CEO at the time then reported ill. And when we had to meet, we just got reports that no one was available. And there were delays. Nothing could happen. And there were just unjustified delays in getting the process underway. I then sought legal advice to really get the matter attended to so that I could return to my job. And the legal process also dragged, but finally what happened, to cut a long story short, the SABC then decided to settle, to say we are settling your contract.
No, that's fine, sir.
Yes.
Okay, when did Mr. Motsaneng join SABC?
Mr. Who?
When did Mr. Hlaudi Motsaneng join SABC?
I'm not quite sure because he was employed in the Free State.
Oh, okay.
So I am really not sure when. I don't want to guess that.
Don't worry.
one.
In
Yes.
your recollection, can you compare and contrast the qualifications of Mr. Motsaneng and that of Ms. Phumelele Nzimande?
Oh no, it's a world
Briefly,
of it's a world of difference. Mrs. Ntombela Nzimande has a postgraduate qualification.
Okay,
I cannot
thank you.
speak for Mr.
All
Motsoeneng.
right. Was the chairman, Dr. Ngubane, ever challenged for backtracking from his original position where he allegedly attributed the invitation of Mr. Motsaneng to the board meeting to the board, when he backtracked and said, no, he was using his own prerogative as a chairman? Was he challenged by yourself or maybe Advocate Tawe Mahlati, who
yes,
is cited in your statement?
Oh yes, indeed.
And what was the response?
It became a big issue at the board meeting, and not only Advocate Tawe Mahlati raised it, other board members also joined in to express their disapproval. And of course, at the end of all that, then the board chairperson said, well, it was his prerogative.
I'm going to ask you the question that I asked Mr. Naidu. Can you identify 3 key political players that may have played a role in this misgovernance of the SABC?
I don't quite understand. You say who contributed to all this?
Yes. And I'm zooming into the political players. And there is a reason why I am saying that. I believe that such things sometimes, I'm not saying it can happen. Maybe it may not be there, but sometimes when people have some authority somewhere, you've made reference to some authority somewhere, and maybe you have some ideas about which authority is that. And I want you to be honest and share that authority with us. That authority, and I assume, maybe you can answer me, is that authority political or administrative or whatever? What authority are we talking about here?
I'm really not shielding anybody, but your 5 minutes is up, sir.
Thank you.
ma'am.
Thank you, Chair.
Honorable Van Damme.
Thanks, Chair. Mr. Molefe, can you speak to me about the character of Mr. Motsoneng? How does a person who does not have the requisite qualifications for a specific role find himself as GE stakeholder relations, sitting in board meetings? How does that happen?
I
Is he
think
a
it's a
smooth-
mystery. I think it's a mystery. But having said that, it's a mystery that points to the existence of something that he derives his power from somewhere. Where does he derive it from? I don't know.
To continue with Honorable Koza's line of questioning, in my mind, with the facts that I have in front of me, it would appear as if Mr. Motsoneng has some sort of political protection or someone in high office who constantly, makes sure that Mr. Motsoneng gets what he wants. Would you say he has political protection?
Yes, that is very possible.
Would you say, was the name of the president, for example, ever mentioned in connection to Mr. Motsoneng? The current Minister of Communications famously said, Ubaba loves Uhlaudi, we must protect him. When you were CEO, was the name of the president ever mentioned in relation to Hlaudi?
Yes, it was raised.
In what context, sir?
Well, in the context that there is some form of protection from the president himself.
Can you elaborate? When did that happen? Who said that? Please give me details.
Well, I think in the public space, it first emerged when the minister herself said, this is the president's choice. So, in the public space, that was widely reported on. But also in the corridors, it is something that is widely spoken about, that there must be a force somewhere, we don't know where, but somewhere, that protects him. Because just look at it in the space of the last 5 to 6 years. Very, very senior and experienced executive members of the SABC were removed, starting with Mrs. Ntombela Nzimande, coming with me, and many others, up until fairly recently. And really nothing has happened. But you have also had court rulings and appeals, and you still found that the man stayed on. So clearly that speaks to the existence of a powerful force.
Indeed. Would you say that that powerful force, likely the president, would have supported the removal of? You were removed because you didn't agree with Mr. Motsoneng. the person who took the job after you, Mrs. Mahobo, she was removed from her position. Several people have been removed in their positions because they didn't agree with Mr. Motsoeneng, or maybe because he coveted the positions that they held. Would you say there was some political pressure for people who Mr. Motsoeneng didn't agree with, or whose positions he wanted were removed?
Well, I think with due respect, I have tried to assist the committee to say there is a powerful force, but I would be very wary to speculate as to what that force is. My view, Chairperson, is that the committee has at its disposal the power to pursue this matter further and to investigate and to find out. The Office of the Public Protector has demonstrated that you can actually even establish the whereabouts of people. If someone had said, I'm going to Pretoria tonight, you can establish the presence of the person with military precision. And surely some places there are no shebeens around there to establish that.
Okay,
Where were
thank
they?
you, thank you. One last question. Are you aware of any other deals with the Guptas that may have happened around that time? Other than the TNA deal, were there other instances where the Guptas tried to do business with the SABC?
No, not in my time.
All right, thank you very much.
Thank you.
Honorable Mahlangu.
Chair, thank you. Mr. Molefe, you indicated earlier on that Mr. Motsoeneng came from the Free State. One would assume that he came from Lesedi station, because that's the only station that you find in the Free State at the time. Who was the HR at SABC who would have known about Mr. Motsoeneng's landing at your HQ?
I think at the time, and I'm subject to correction, given honorable member the size of the SABC, but I think at the time the HR person was Mr. Paul Tati, T-A-T-I.
Okay. Going to Pretoria, how did that impact or have an effect after the return from Pretoria on you, as well as the SABC? I mean, dealing with that question, you remember there was a discussion with Mr. Ngubane and so on, going to Pretoria, and then if you could just narrate to the committee as to what then did you pick up that this may be the Pretoria effect?
Well, right from the moment when I declined to approve the salary increment, I knew that I had taken on a course that would amount to the jeopardizing of my career. And when did I pick that up? I think a week after that meeting, there were interviews that were going to be held with the board and the agency that was running the recruitment for the group CEO candidates. And that interview process was tampered with, and the interviews were then postponed indefinitely. And finally, the interviews were held in January instead of the scheduled time in December of 2011. And from that point on, it was quite evident to me that something was now really happening with regard to the veiled threat that had been made.
Before Mr. Motsoeneng held the group position for whatever that includes provinces and stakeholder, what position was he holding?
Before that, he had been brought to Johannesburg and appointed general manager in the office of the group CEO. And I may hasten to add, Chairperson, that that appointment also, in my view, was irregular, because he was literally airlifted from the Free State, straight parachuted into the office of the group CEO, and given the title of general manager in the office of Group CEO, and that position did not exist at the time.
And who was the group CEO at the time?
Mr. Soli Mokwetli.
Okay. Okay. I guess, Chair, I should end my question here because I think some of the things have been covered by my colleagues previously.
Honorable Mokwena.
Thank you, Chair. Dr. Molefe, who was the Minister of Communications at the time? It was Mr. Karim, was it not?
No. The minister at the time was Ms. Dina Pule.
Dina Pule?
Yes, indeed.
Okay. The relationship between the minister and Mr. Ngubane, how would you describe that?
I think it was a normal, cordial relationship.
Nothing special about?
No,
that?
nothing
Yeah,
really.
yeah.
Yes.
So, when Mr. Hlaudi says that he would leave, that he would go to Pretoria to report on this 500,000 thing, it would be out of the ordinary that he was talking about Ms. Dina Pule, who was just a normal minister doing her work properly, would it?
My take is he had actually made this point that he's going to Pretoria, and it was not necessarily about 500,000.
Okay.
It was in the context of saying, this is not our man.
Okay.
So now I am going to Pretoria.
Did you get a sense, though, that he reported everything, given the fact that he was also just sitting in meetings and not doing anything, that he was reporting to somebody on a regular basis about the goings-on of the SABC?
I mean, it creates such an impression, and it does leave one with that impression that there is a regular contact of sort with this line to Pretoria, if it even gets to a point where we disagree on an increment, that would then trigger the response to say, I will be going to Pretoria.
Okay. The Gupta arrangement, the chair of the board would have been aware of such an arrangement, or at least a suggestion of such an arrangement. Is that correct?
Well, I know that the chairperson of the board at the time was aware of that breakfast thing because they had attended some of those events with Hlaudi.
Was it executed during his time?
I am not sure. What I know is I had refused to sign that contract.
So it didn't happen in your tenure?
The contract?
Yeah.
The activity happened, but the contract was not signed.
I see. What was the stake of that the Guptas were asking for in the news channel as it was proposed? I know it wasn't signed during your time, but what was the stake that was being propelled at the time?
No, there was no contract with regard to that on paper.
Yeah.
It was a discussion around having a partnership for.
But what was the stake of the Guptas in those discussions that they were proposing?
No, that was not stated.
That was not stated.
Yes.
Okay. And then you're leaving the organization with the circumstances quickly in just 15 seconds, because I want to ask you another question.
Not going to ask another question. The 15 seconds left.
Chair, I think you're particularly unfair with me. What was the circumstances? You said you were forced to leave.
Well, basically, I mean, unreasonable demands were made to me. Things like I have to submit the editorial diary to the group CEO every day. Things that I know had never happened in the SABC in all the years that I have been there. And I had reported to group CEOs such as Zwelakhe Sisulu and Mrs. Cecilia Kuzwayo, and there had never been such an expectation from the newsroom. More so that even the editorial policy was very clear that editorial decisions vest with the newsroom. So making that situation, therefore, difficult for me to bear, and then writing back to the authority at the time to say, I think this demand goes against the spirit and letter of the editorial policies of the SABC, disciplinary processes were then instituted against me. And then it's the long story that I explained, and finally, that then resulted in my being taken out of the organization.
At that point, sir, I want to say thank you very much. Now, if you don't trust my timekeeping, everybody is at liberty to keep their time individually. I'll be fair to the letter.
No, Chair, I think maybe it may not be you, it may be your watch.
Okay.
Which has a problem with me.
I've got two timekeepers here. Mr. Molefe, thank you very much, sir. But as has become practice, unfortunately, time is what we have to respect. But between today, or between this minute and the 28th of February 2017, when we are due according to mandate to present our report, if something crops up, you are at liberty to keep talking to the committee. You could send stuff to the committee secretary, and as and when these things come to us, I will share it with the committee who sits in open meetings. So this is not the end of the road by a long stretch. If you want to, you are able to and are at liberty to do so. But for now, we wish you well. Have a good Friday, sir. And if we don't see you, have a very Merry Christmas and a prosperous New Year. Honorable members, at this point, we will break for lunch. The next meeting, the next sitting is at 2 o'clock. I know Cindy's already looking at me, probably saying lunch is not ready because we had scheduled it for a bit later. However, we're not going to start with the next one now because it has been scheduled for 2. So you've got between now and 2 to do whatever you want to do, but at 2 o'clock, please be here because we're going to kickstart with the last approach. Thank you very much, and thank you, sir.
Well, hearing there from a former employee and also a person who has had quite extensive executive positions for a number of years within the SABC, including that of acting CEO, Mr. Molefe. He gave some of the most damning revelations that we've heard so far, and being questioned there on today, day 3 of these inquiries into the SABC's board fitness to hold office. He did say there that there has been an erosion of governance that has started to take root in the SABC as far back as 2011. We also
not will stay.
We, according to our logistics managers, have it that he would have arrived or is scheduled to arrive in Cape Town at 12. So the minute he arrives, we'll ask him to rush here. And the minute he arrives here, we will call you wherever you are, and we'll start. Is that okay? So if somebody can ensure that the lunch is done now, because this meeting's decision is that as soon as Mr. Tsietsi arrives, we will proceed. So don't complain that you were in the middle of your lunch when I call you back. At this point, we will adjourn until well, no later than 2 o'clock. Yes, until call. Thank you very much. Yeah, and before that, can all members here just retreat to E209?